Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausam Pereira. A legal opinion sought by the Centre on a Law Commission report on the British-era sedition law has stated that Section 124A, sedition as interpreted by the Supreme Court, is necessary. In short, it is unlikely that the IPC section on sedition is diluted or scrapped. In September 2016, the Supreme Court had reiterated that a larger bench had already provided necessary safeguards that should be followed by all authorities, and every magistrate is bound by what it said in the Kedar Nath case. It was referring to the order in the Kedar Nath Singh versus State of Bihar case in 1962, in which a constitution bench had ruled in favour of the constitutional validity of Section 124A, but had added a vital caveat that a person could be prosecuted for sedition only if his acts caused incitement to violence or intention or tendency to create public disorder or cause disturbance of public peace. In August last year, the Law Commission submitted a consultation paper to the Centre on the need for changes in the law, pointing out that even the United Kingdom abolished sedition laws 10 years ago, saying that the country did not want to be quoted as an example of one using such draconian laws. A report in the Indian Express said while a final decision on whether to dilute the law or not is yet to be made public, but various stakeholders, including state governments and law enforcement agencies, have expressed the need to retain the law without changes. On this edition of The Big Picture, we will analyze the sedition law and its utility. Joining me on the program today are J. Sai Deepak, Advocate of the Supreme Court; Subhash C. Raina, former Dean, Law Faculty, Delhi University; Soli Sorabji, former Attorney General of India; and Professor Rajveer Sharma, political analyst. Thank you to all my guests for joining me on this edition of The Big Picture. Mr. Sorabji, I'd like to begin the program with you and try and understand and try and find out from you, of course, your thoughts on the British-era sedition law. And should it stay or has it outlived its utility?
Well, the law as interpreted by the Supreme Court is no longer the British colonial law. In other words or actions criticizing the government, however pungent the criticism, however ill-informed the criticism, is not sedition. The essential ingredient of sedition is there must be incitement to violence. Absent the incitement to violence, you can't suppress speech on the ground of sedition. That's clear. That's in Kedar Nath's case and subsequent Supreme Court cases. So I do feel that we do require the law to meet certain situations, but the mere misuse of the law is no ground to repeal it. The whole real remedy is to check the misuse by instructing the authorities not to put the law in action against people who merely criticize government, however strong the criticism.
Right.
That's the balance between free speech and the security of state. Sorry.
Right. So, as Mr. Sorabji is suggesting, I'll come back to you, Mr. Sorabji, in just a bit. But before that, Subhash Raina, let's try and understand first, of course, what is sedition and who can be tried for it.
I think Soli Sorabji has well said that any group of people or any person who actually tries to create disaffection towards the government, which he says should result into violence, is seditious. But the fact is that immediately saying that we should rub it off from the statute book seems to be something that we label everything IPC whole is by the Britishers. It does not mean that we should rub all IPC, except that whatever the social change needs to be. We have amended IPC at times on different areas. For example, we amended in rape laws, we amended in 377, we amended it in adultery. But there doesn't seem to be need to amend it immediately on 124. Because we have a strong judiciary, and I say strong, it means an independent judiciary, which takes care of that anybody who has been alleged to have done so will not immediately be crucified. There's a procedure of trial, and the trial is under a due process of law. Nobody violates the due process of law, even for enemies. We have not violated the due process of law. So anybody who goes under the due process of law, if found guilty, will be a rare case where the sedition will take place. See, I will just give example. See, before independence, we have 5-6 cases of sedition. After independence, we have alleged the cases. I doubt we have said anything about it, except that if the Supreme Court, again I will say to Saurabh Saurajya, that in Kedar Nath's case, if the Supreme Court says, yes, it should not violate it, I don't think we should rush and say we should abrogate it. And Law Commission report of August 2018, if you read the last page, has also stated that there need to be certain restrictions to be kept on it. Those restrictions may perhaps make sure that it is not violated in the letter and spirit, or the human rights are not violated if we apply seditious laws. Otherwise, those who know it can very well understand as to when it happens and how it happens.
Right. Jai Sai Deepa, so what about free speech? And also, what does section 124 of A of the Indian Penal Code state?
So, as far as I am concerned, the limits of free speech are to be judged on the anvils of what amounts to a reasonable restriction in the backdrop of Article 19(2) specifically. And that is precisely the question that the Supreme Court has considered in Kedar Nath as well. And the court has arrived at the conclusion that the test of reasonableness is satisfied if you limit the scope of application of the provision to the situation where any statement that you make amounts to incitement of violence. Okay, so I think that's a very reasonable interpretation. But when you discuss free speech, I think it's important to broaden the scope of the discussion a bit more. Because if the integrity of the Indian state can be challenged, and if the integrity and the existence of the Indian state can be questioned, and there can be sloganeering against it in educational institutions or elsewhere, then why do we have any provision protecting religious sentiments as well? Because if free speech is the issue, then India, keeping with the advancement of other jurisdictions, should not have any blasphemy related laws as well. But then we have a 295A, then we had a recent provision that came out in Punjab with respect to blasphemy. So the question that I'm asking myself is, free speech becomes a convenient talking point when the discussion is about sedition laws. But free speech takes a backseat the moment it is a question of religious sentiments. Surely the Indian state cannot be less sacred than religious sentiments, because at the end of the day, it is that state and it is this particular country that guarantees your right to speak whatever you wish to. So if you want to have a discussion on free speech, it needs to be comprehensive and across the board. So 153A, 295A, and also with respect to expression by way of books, what amounts to obscenity, obscene publications, all these questions need to be answered as far as I am concerned. So if you are for free speech absolutism, then it must apply to every issue, every entity, be it the Indian state or religious institution.
So there has to be some kind of uniformity is what you're suggesting.
Absolutely. We cannot use free speech as a convenient tool to evade certain discussions.
Right. Professor Rajvi Sharma, so why has this issue come to the forefront yet again?
You see, this issue of whether section 124 or 4A of IPC should be retained or should not be retained has almost been a matter of discussion and debate for quite some time. And the matter has gone on various occasions to the judiciary as well. In 1959, the matter went to the judiciary. Then and again in 1962, the matter was referred to the judiciary through a petition. And even the Law Commission has examined the issue which you were referring to in 2016. And the conclusion that has been drawn so far is that there is a need to retain section 124A of the IPC. The reason is that the context and the cause of the IPC 124A has not disappeared. The fissiparous tendencies are still live. The divisive forces are still active. And I don't buy the argument that if the freedom of speech in case of religion, I don't think even in case of religion, freedom of speech is absolute. You cannot spread hatred even amongst the religion communities and religious communities. You cannot speak anything and everything because you have a right to freedom of speech and freedom of religion, and under that cover you exercise your freedom of speech and expression. And number two, the kind of the threat to the unity and integrity and sovereignty of the nation and the kind of the reference that is made to religion are not similar in nature, and they really demand a kind of a different treatment on its own scale. Now, having said that, I think even the Supreme Court has said very clearly that so far as dissent is concerned, so far as criticism of the government is concerned, you are free to make any strong criticism of the government as well. You can make any kind of a strong language of against the government on policies, but that dissent should not be turned into some kind of a persuasion to break the country. I mean, whether if you attempt to break the country either through words, action or persuasion, naturally the law should take its own course insofar as sedition is concerned. And nobody can be allowed to really take this opportunity that this is my freedom of speech and expression, and therefore I will say the Bharat tere tukde honge inshallah, inshallah. It cannot be permitted. And similarly, if I spread hatred against any religion, I think action is still being taken against those persons.
Right. Yes, Jai Deepak, you want to say
So
something?
here's the point. If you look at the ratio of the judgment of Shreya Singhal and the grounds on which section 66A was struck down, the court took the position that offence being caused to somebody's sentiments cannot be a limit on free speech and cannot be a limit that can be used as a justification for section 66A. So the basic point perhaps which I was making has been misunderstood. The point I am trying to make is this: the threshold for invocation of 295A for offending religious sentiments is lower than the threshold required for sedition. For sedition, you need to actually go to the extent of incitement of violence. But when it comes to religious sentiments, merely because somebody's sentiments are hurt, whether it is your intention to spread hatred or not, or whether you are speaking the truth, really it does not matter as long as somebody's sentiments are hurt. That particular argument is problematic because if, let's say, a certain historical aspect or historical figure is being discussed and his lives and times are being discussed, or her lives and times are being discussed with respect to the religion that he or she may have started, and when the analysis happens, if the analysis reveals certain uncomfortable truths, would that amount to spreading hatred? What is the line that you draw between speaking the truth and spreading hatred?
Right.
That is the question.
Right. Mr. Sorabji, I can see you also putting up your hand. Go ahead, please.
No, the requirement is that it must be with the deliberate intent of hurting the religious feelings. That's the requirement. Otherwise, I agree. Criticism, however strong, however vigorous, however ill-informed, is not sedition. But 124A will come into picture if there is some sort of an incitement of violence. For example, if you say Pakistan Zindabad, well, very deplorable, but that's not sedition. But if you say Hindustan Murdabad, and now time has come to take other means, we can't do without it, and there's an incitement to violence and a tendency of the speech to cause public disorder, then the section is invoked. And any section can be misused of the penal code. Can't cheating be misused? But mere misuse is no ground for its repeal, for its discontinuance. If we keep this in mind, the sedition law can only be applied in these cases where there is incitement to violence, or the words or action or writing have a tendency to create public disorder, not otherwise.
Right. So, Mr.
Mere
Sorab,
criticism is no ground for suppressing free speech.
so Mr. Sorabji, how do we check this misuse then?
Check the misuse. Where if the misuse is there, you acquit the people. If the misuse is there, in a given case, you acquit the people who are charged with sedition without sedition. I think it also there's need to really impress upon the authorities to use this section in the proper manner. And if they don't use it properly, my one suggestion is take action against the authorities.
Right. All right. Jai Deepak, you know, the Kedar Nath case versus State of Bihar of 1962 has been brought up on several occasions. What is the history of the case, and what was the final verdict really as far as this particular case is concerned?
See, I think Mr. Saurabhji has already clarified what exactly is the benchmark or the test that is laid down by that particular judgment, and I don't think I can add value to that particular issue. As far as the history of this particular provision itself is concerned, this was obviously brought at a certain point of time when the British Indian government wanted to clamp down on people who were asking for independence. Now, notwithstanding the fact that this may have been a British import, it has received a stamp of approval from the Indian Supreme Court in 1962, and therefore that provision has gone through an Indianization, so to speak, and it has been tested on the annals of the Constitution. Okay, so the fact that it happens to be a British import is something that cannot be used to create prejudice with that particular provision, because the question that you have to ask yourself is it relevant at this particular point of time? So let's ask ourselves a few questions. So just to add to the example that Mr. Saurabhji had pointed out, Pakistan Zindabad may not be seditious because that's a statement in support of a certain country but not against India. Therefore, when would that statement become seditious? If India declares that Pakistan is an enemy country, that is when that particular statement becomes seditious. At a time when there are multiple flashpoints in this particular country, and there are a lot of, I would use the term which has now attained a certain amount of significance, breaking India forces, so to speak, which are alive, which are kicking, and which are receiving active support from within and outside. I think this law is important. The fact that this particular law has been done away with in other jurisdictions is no reason to slavishly follow that particular procedure without asking ourselves what is the relevance as far as our circumstances are concerned. Point number two, the one question that I have always asked myself is India as a country or as a culture less open to criticism or less open to, let's say, any kind of challenge to established notions? Actually, no. Our culture, it invites criticism. There's no problem with it at all. It encourages criticism. So the problem is, you can criticize the government and you can even perhaps criticize the Indian state if you believe that it has meted out injustice to certain communities. Even that argument can be made. But are you making that argument to reform the existing condition, or are you asking for the dissolution of the state altogether? That is where the line needs to be drawn. Similarly, why I brought in the religious angle is because I find it a tendency to bring in free speech as an argument extensively the moment sedition is discussed. Okay, but when it comes to religious sentiments, we are extremely cagey. Why is it that we are incapable of having a discussion? So let's put it this way. There are certain faith systems which clearly reject the sanctity of the Vedas, and still they are treated as religions. That is perfectly possible. So from a theological standpoint, there is a criticism of the Vedas which is close to one particular community. Okay. Similarly, it must be possible to reject the theological basis of certain other faiths as well, and that should not immediately invite any comment of hatred, because hatred is too strong a word to use. I may genuinely disagree with a certain proposition without necessarily being hateful of a certain person or a certain entity. I can reject that particular idea and say that this particular idea could cause public disharmony and therefore it should not exist. But that's not the same as saying that you have a problem with the followers of a particular belief system. That distinction unfortunately is missed.
So critical analysis of all communities should be allowed and should be there is what
because
you're suggesting. Because
then there can never be an academic discussion with respect to faith systems at all. Then the right of the academia to think and the right of the public to receive that particular piece of information, because the right of the receiver has been recognized in the Shreya Singhal judgment, even that is lost. If a book is published criticizing a particular faith, not only is there a right of the author, the right of the publisher, but the right of the reader to study that as well, to consume that particular piece of information as well. So I think these are aspects that need to be considered when you're discussing free speech and all these laws, which are reasonable restrictions on free speech. Whether 295A is a reasonable restriction on free speech is something that the Supreme Court has already decided. But I think that particular issue warrants a greater review than with respect to sedition, because laws against sedition must continue, but law which prevents discussion of religion must be reconsidered.
Right. So talking about the Kedar Nath case, Subhash Raina, there is a caveat as far as that particular case is concerned, and is that caveat enough of a safeguard really when it comes to sedition?
May I say it in a different way, sir? I agree to the extent with my friend that religious sentiments may not be raised to the extent. But I think law of sedition is against state. It's not either against you nor against me. It has nothing to do with the individuals, nor with the group of individuals. Therefore, religion is my individual perception. Even if somebody says it, I don't agree with it, I agree with him that, okay, he doesn't agree with me. It is no sedition at all. It becomes seditious only when it is against the state. When I say or challenge the sovereignty and integrity of state, I will give the live example, perhaps people may hesitate to give it. If somebody has seen Kashmir from 89 to 94, one can see what sedition means. It was exactly that during the night, slogans was raised, and the practical part of it are always in the morning. That's what Suri Sorabji says, that unless it results into violence, you may say anything. You may say, I like A, I like B, but unless it results in the hatred of C and D, that was the position for the 5-6 years in Kashmir. That's the reason. That's why we sometimes say if the slogan is raised, as Suri Sorabji says, in favor of one state, but unless it is against the other state, it will not become seditious. The second is that when the caveat is there, I think we need not to worry about it. If the Supreme Court says yes, we will not go beyond this, I think what you have been concerned about is how can we make it then definite that nobody is being had to be guilty of seditious unnecessarily. I think the law of evidence, it's clear. It's an allegation, suppose it's an allegation against me, but unless it is proved beyond reasonable doubt, our system of judicial system is adverse, completely. We have to prove it by evidence, we have to prove it by procedure. So unless the procedure and evidence satisfies the court of law who hears the case, it's not seditious at all. That's what I said at the beginning, that the judiciary is so robust and strong that they will not allow it to happen. Unless we lose faith in judiciary and say so. But we should not lose faith, because in Shreya Singhal, they have not allowed us to add one more. That's the reason 19.2 has been restricted to what statutory 19.2 is. It has not, we have not been allowed to say no, yes it is. So anybody writing book, if it violates my rights, my personal problem, I will go to somebody. If it violates the right of a group, it's so long good. But if it says like something against the state, then my existence in danger, including the existence of the state. Only then it becomes seditious and we will move to the court of law. That's what the caveat in Kedar Nath.
Absolutely. Rajesh Sharma, as far as there are many who believe that, who need some assurance really as far as sedition is concerned. Do they need some kind of a clarification, or do you believe that no clarity is required at this point in time?
I think this clarity has been given by the court from time to time, and very clear lines have been in fact drawn by the judiciary as to what really constitutes sedition. And at the same time, if you look at the acts of sedition, the court has very well said that it should not be an act inciting or aiming at inciting the violence, or it should not aim at spreading hatred against the state, or it should not aim at the kind of spreading disaffection against the state, which really means that you want to overthrow by actions. And so even posters which spread disaffection or hatred against the state are not allowed. That is, even visible representation of this hatred is not allowed. That is what the court has very well said. And even now we see that there are so many political actors who use posters which are not really in a good taste and maybe interpreted as spreading disaffection or hatred against the government or against the state. So this is one side of it, and I broadly agree that there should be some kind of a debate at some other time as to what are the limits and scope of freedom of speech and expression. But today, if you look at Article 19(1)(a) and then again Article 19(2), then these should be read together. That we have a freedom of speech and expression which has been guaranteed under Article 19(1)(a), but at the same time there are limitations counted in Article 19(2), and these limitations have to be of course reasonable, but at the same time the public peace, the public order, the morality and so on. I mean, they are provided a long list as to where the reasonable restrictions can be levied. So therefore there is no conflict even there. Right. As to what constitutes freedom of speech and what constitutes the acts which are against the nation. Disloyalty to the country also can be interpreted as an act of sedition.
Right. Right. Okay. Closing comments now from all my guests with the best way forward. Starting first with you, Mr. Sorabji.
Sorry?
Closing comments. The best way forward. You spoke about how repealing the law is not an option, but maybe dilution somewhere.
Best way forward is to educate the law enforcing authorities and really coming down at penalties on them when they invoke the law when it's not to be invoked. One thing is very clear. Disapproval of government policies, government attitude is not sedition. however much you may pungently express it, it is only with it creates tendency to incite our violence. So that must be clearly brought out, and the law authorities must be, I think, educated properly. And I'm sure your debate today will help to some extent in that direction.
Right. Desai Deepak.
So, even after Section 66A was struck down by the Supreme Court, there were several cases where it was continued to be foisted on people, and people were charged under that particular provision. So, frankly speaking, there is really no cure for stupidity in some instances, as far as I am concerned, or ignorance for that particular matter. The judiciary has done its job of striking down that particular provision, but if somebody continues to implement it, then, as Mr. Saurabh ji rightly points out, it's a question of awareness. But it's also a question of the kind and quality of input that you get into your law enforcement agencies.
Right.
How are you equipping it? How are you making it a better place for better people to enter that particular profession? So, as far as I am concerned, the law of the land is laid down by the Supreme Court, but the law in operation is effectively in the hands of the SHO at the police station and the beat police constable. So, that particular mismatch and that particular gap can be perhaps addressed through awareness.
Right. Subhash Raina?
Sure. I think we have been tolerant and we need to be more tolerant so far as communities are concerned. There's a problem or a friction between communities. Basically, when we say sedition for the last 10-15 years, it's only some fragile thing which happens within the community and it goes on the seditious side. That's where the law enforcement agencies can play some role, otherwise education. And I think I'll take you also into confidence that journalists have to play the most important role. It's the journalism which has spoiled the seditious law in country. I'm sorry to say so. It's the journalism which has spoiled because they have their own writings and sell newspapers in the morning, as well as those who do not know what the sedition basically is. So somebody says something, we say it is a seditious law. We need to be tolerant and teach to the people that it is not sedition.
Right.
Somebody saying anything against me. Plus, of course, unless the police is being insulated from politics, howsoever great SHO may be, he will remain like that.
Sure. Ajay Sharma, close the show for us with your concluding remarks.
I think two things I would like to say that India, one, is a very open and a liberal democratic society. It generally does not tolerate any kind of a misuse of authority by anyone. But at the same time, since we know the challenges before the country, particularly in the form of over the ground Naxals and underground the Naxals, the divisive forces still they are there. I think it is necessary to retain the sedition law, even though it is a necessary evil. It has to be retained.
So it's not outlived its utility yet, is what you're suggesting. Maybe there will be a time somewhere in the near future where we do not need the sedition law, is what the panelists are suggesting. On that note, it's a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.